Well, good morning, everyone, and thank you for joining us today for the legal webinar. My name is Keith Bray, and I am the General Counsel and Chief of Staff at CSBA, and I will be facilitating today's webinar. Before we get started, I want to make a few quick announcements. If at any time you have a question for presenters or a technical issue, please use the Questions tab of your GoToWebinar dashboard. So on your dashboard, you have that Questions tab. Please use that for questions during our webinar today. At this time, I'd like to introduce today's panel, who's going to be handling our discussion. First is Namita Brown. Hi, Namita, Fagan Friedman, and Cole Frost. We have Sarah Kotz. Sarah.
Good morning.
Lozano Smith. Josh Morrison. Where are you, Josh?
I'm right here. Good morning, Keith.
There you go. And Josh is from Atkinson, Andelson, Lawyer, Rudd, and Romo. And Marie Nakamura from Dennis, Walliver, and Kelly. Hi, Marie.
Good morning.
Before we start this morning, I would like to make a few introductory comments. We are in trying times for sure, but you don't need 5 attorneys to tell you that. Governing boards up and down the state are now planning or have already decided to have students return to school or to provide distance learning again, or to do a combination of the two. Resources are stretched in every budget, not to mention the state budget, which went from a projected surplus of $5.6 billion in January to a projected $54 billion deficit in June. Children are staying home with their parents, and parents are staying home with their kids, some of who just graduated from college. So many personal and small business budgets are being stretched and torn. So many rites of passage are being shorn. So many have suffered alone. But for some, working from home has helped strengthen their personal relationships. And for others, it has provided the time to think more deeply about the issues of equity and civil rights. And yes, staying home has cooled the planet. So against this backdrop, we are holding a webinar in the middle of July while this virus is spiking. July is a month when many governing boards don't even schedule meetings, and school employees are usually elsewhere trying to catch their breath from the year before. But here we are. So during the first half of the webinar, we are going to present some information we hope you find helpful as you continue to think about the issues facing your district or county office. In the second half, this panel of very capable attorneys will be answering questions you have submitted ahead of time or the ones you are submitting to us this morning in real time. We hope to have as many answers as there are questions, but that is not a proposition we can guarantee. So with the time we have left, a little over 85 minutes, let's get started. This is the sequence that we're going to go through this morning with the presentations before we get to the questions. We may be answering the questions as we go along by the comments of the panelists. We're going to start this morning with Josh Morrison. Josh, again, is with the law firm of Atkinson, Andelson, Lawyer, Rudd, and Romo. The opening of schools goes right into this balancing act of what's best for students educationally. When we compare that with the data that we're getting about our local health conditions and recommendations from state and local health officials. So Josh is going to take us through a bit of the foundation of the legal underpinnings for these orders and guidances before we get to a discussion about distance learning that has been provided to us by SB 98. So Josh, and if we could have the next slide, please. And Josh, feel free to move the slides until we get to the presentation on the implementation and the accountability of distance learning.
All right, real good. Thank you. Good morning, everyone. What I'm going to do just initially here is a little foundational background information. I think everyone knows how a bill becomes a law. We've all seen that video from the time we were children. I don't think it's entirely clear how an executive order becomes a law or becomes binding, how health orders become binding. And so we're going to talk just briefly about that so people have a little bit of foundation. There is a structure within the law for the governor to issue executive orders. There's a reference on this slide to the government code sections that allow that. I think we've all seen the governor issuing executive orders, sometimes on a daily basis. We will likely see that continuing, especially as we get into the fall semester. But there is a structure. It's set out in the government code. These are contemplated under the law. If we can move ahead to the next slide, please. There's also court decisions, some going far back. We've got one from 1919. We've got one that's more recent. And these decisions collectively establish that it's a valid exercise of public authority to take action to control communicable disease, to prevent the spread of disease. And so the concept that the state has the power to step in and take action in the event of a pandemic, obviously the situation we're in right now, that's long established, and that's well established. Where we see quite a bit of the rubber meeting the road, though, is in the terms of the state and the local health orders. And if we can move to the next slide. There's authority in the Health and Safety Code that confers power on the State Department of Public Health and local departments of public health, which are frequently county departments, but there are some cities that have their own health departments and are authorized to issue orders of this sort. And the law contemplates that both the state and the local health departments can take measures to prevent the spread of disease. And what those measures might consist of, mask orders, mask mandates, things of that sort. We've seen quite a bit of variety, and sometimes those are changing on a daily basis. And we're also seeing different decisions made from county to county. But it is contemplated to the extent people are saying, "Hey, there's no foundation for this. There's no authority." That's not quite right. There is authority under the Health and Safety Code that provides an underpinning for these health orders. And if we can move to the next slide. All right, we're not going to go through all of these, or I'm not going to go through all of these right now in great detail, but I do want to talk generally about some of the orders that are out there, some of the guidance that is out there. California Department of Public Health, State Department of Public Health, has authority, as we just saw, to issue orders to take action to prevent the spread of disease. Some of the things they put out, though, are identified as non-mandatory. They're not fully exercising their power to compel. They're providing guidance. And so the guidance that they issued on June 5th, aimed at schools and school-based programs, had a few caveats. It wasn't a "thou shalt do this." They said it should be implemented with county health officer approval. And so there's some non-mandatory aspects of that. California Department of Education issued their Stronger Together guidance. That's optional. That's presented as optional. It's something that is for your consideration. We've also got California Department of Public Health guidance. The order that requires the use of face coverings. We are seeing that as mandatory. I know there are different entities that are saying, "Hey, we'd like to require masks in some circumstances, but not others." We are seeing this as essentially a mandatory directive on a statewide basis, at least until further notice. And obviously, all of these are subject to change. I also want to briefly talk about Centers for Disease Control, CDC considerations for K-12 schools. This is presented as an optional readiness and planning tool. There's a lot of information in the CDC guidance. I would certainly urge districts to look at and consider all of these. That one in particular, though, is not identified as binding, and you may or may not be adopting considerations in there. And then also we've got a brief mention of SB 98, and I just want to take this opportunity to note that there's a lot of different places, SB 98 being one, where there are references to state public health orders and guidance, local public health orders and guidance. Some of you have collective bargaining language that refers to orders and guidance from public health officials. It's important to know what you're getting into. and what you need to refer to. And so I would certainly, as you're kind of sitting down trying to see, hey, what are our responsibilities? Let's keep an eye on the fact that we've got state guidance, we've got local guidance, we've got CDE, the CDC. There's a whole bunch of stuff. It's important to keep all of that in mind, but also to keep focused on what is absolutely required and what is essentially optional.
And Josh, before we move to the next slide, let's talk a little bit about CDC. We heard last week from the president that its guidance that it had put out that you referred to was going to be changed this week, and so far we're waiting for that shoe to drop. Didn't we also have the governor on Monday talk about a potential new guidance for this week?
Yeah, we're well with the CDC guidance in particular. The president sort of pushed back, but it wasn't entirely clear to me what he was pushing back against, because it was presented as optional guidance for consideration by districts. In terms of the governor, he issued, I believe, a directive yesterday talking about testing priority. And if we're looking to get back to school, if we're looking to have some form of coronavirus testing as part of that, we've now got a testing priority that puts asymptomatic people last and may impact their ability to get tests going forward. But we're going to see changes on a regular basis with all of this guidance.
Right. That's really the point, right? I mean, what was issued yesterday by the California Department of Public Health was an update on their interim guidance. And as it turned out, school employees that have contact with students and the public are in the 4th tier, which is near the bottom as well. So, and the governor on Monday also said that he looked forward. He was kind of given a little preview. He was saying that what's now being reviewed, the peer review process going through his administration, and probably also the Department of Education and others, that maybe on Friday there would be more information for us to consider about masks, about buses, about sports and choir. So I think the point here is not to, hold either the president or the governor to what they're saying they're going to do, but to indicate that, again, this is over a wide spectrum of, hey, this is what we're trying to do for you, and we are continually giving you that information. CSBA also put out a guidance, and it's on our website, the uncertain road ahead, and it really is a great planning document. It utilized many of the same resources that these other guidances did to come up with planning that both school districts and county offices can be using. So wanted to let the folks know that there's always that guidance as well. Are you ready for the next slide?
Yes, please. All right, as I mentioned, the local, county, and in some cases city health officers are putting out all kinds of guidance. We're not going to go into those, or at least I'm not right now going to go into those in detail, but I wanted to just include a few samples that are different. And certainly, if you're in a county that has issued any kind of detailed guidance, you need to be fully aware of that. You need to be making sure that you comply with that to the extent it's imposing directives. But if you're trying to get a health issue resolved or practical advice for how to deal with a particular situation, and it's not fully or clearly addressed in your local guidance, I think there's some value in looking a little bit further afield to other counties to see what guidance they've put out and to see if it has some bearing on your situation. And I will just commend these three. Santa Clara County Public Health put out something very detailed. You may not agree with all aspects of it, but it's helpful. Contra Costa did something very similar. Los Angeles County has a different approach. They've got a list of protocols and it's kind of a checklist. It's mandatory, but it's a different model. But all of these, I would commend to you to take some time, go through them, and see if there are some specific suggestions in there that you can use to supplement your local county guidance. All right, if we can move ahead.
Also on the guidance tree, right, are guidances from county superintendents of schools.
Yes.
And I know, for example, the Orange County Department of Education put out a pretty detailed guidance that they collaborated with the local public health officer. So in terms of, you've gone from federal, state, and local, there's also county superintendents that are, I know here in Sacramento County, one has been put out that's been very helpful for schools to utilize.
Yeah, these are the three I listed are just samples, but I would note that if the county office of ed is putting something out in conjunction with local public health, that's something that will typically be more of a mandatory nature than something that they're putting out without the collaboration of their county public health departments. Let me also note just very briefly, the Orange County Department of Ed, the county superintendent of schools, you're correct, for Orange County did put out guidance in conjunction with the local health officer. We should clearly distinguish that from the action the Orange County Board of Ed took. They are separate entities. I think everyone knows that, but
that's right. What did they do?
Well, they put out some guidance that essentially called into question the suggested opening schools without distancing or without masks. And I think that the county superintendent pushed back, and a number of the districts pushed back. I think districts in Orange County are fully aware of that, but it was a good part of a news cycle within the last day or so.
Thank you, Josh, for sharing that. I wasn't aware. Okay.
All right. If we can, do you want to move to the next slide? Okay. All right. So briefly, in terms of this minor bill, SB 98, I wanted to go over kind of some of the key requirements in terms of in-person versus distance learning. SB 98 does mandate, it says shall offer, and that's just the words in the statute, shall offer in-person instruction. It says you may offer distance learning. And there's a caveat, which essentially says that the apportionment penalties that would typically apply are not going to be imposed prior to September 1st. So if you're providing distance learning, the code section that details all the audit and apportionment requirements that would typically be used to take your funding away are essentially put on hold until September 1st. So I think you've got leeway to not offer in person at least through that date. In terms of the ability to offer distance learning, SB 98 identifies two kind of broad categories. One is as a result of an order of guidance from state or local public health. And I think there is broad authority, particularly in the state California Department of Public Health guidance that came out on June 5th that would allow districts to go distance ed, or at least to offer it. And then the second way is if you've got a student who is medically fragile or at risk, and that at risk category, we're reading that as really very broad. If somebody, it's something different than medically fragile. So it could be risk to parents, it could be risk to grandparents. We're seeing that as really broad authority for parents to choose distance ed. And again, you need to offer in-person instruction. And I think we'll probably talk about LA Unified and some of the other districts that have made pronouncements on that topic. But you need to offer in person, but parents can take the option as long as it's being offered of distance ed. And I think there's very broad authority for districts to do a hybrid program in conjunction with the state or local public health authorities, or to offer a fully distance ed program that parents can opt into. And I think that's about it in terms of the slide.
Well, can we stay here just for a moment? So you touched on it, this notion of an exemption for if in-person is offered, and you were articulated that it shall be offered. And obviously there are some very influential districts in the state that are going to offer in-person only past September 1. But what about the notion of being put at risk? Do any of you have comments about, well, do the parents have to provide proof of that? Do they have to provide a reason, or is it just by their choice?
In my experience, I'm not suggesting to clients that they get any kind of proof from parents. The language is very loose, and although 43502 says shall offer in-person instruction, I think that the exception to that found in 43503, either the first part about working in conjunction with your local health official, or the second part about would put a child at risk, kind of swallows that shall in the first part of the slide. And so
Are they going to
we have
have
not
to,
been requesting information from students. If a student says, I'm opting for full distance learning because of I'm at risk. Yeah.
Okay, that will be good enough. I mean, there's really no test. Namita, did you have an idea?
I agree with Marie. I think the real issue, the real problem the districts are facing is you've got a broad swath of parents who are reluctant to send their kids to school. And so if you don't have a sole virtual model only for these kids who may be immunocompromised or who are medical fragile or who just say that we can't come to school because we are not safe. If the districts are not going to offer such a model, what's going to happen is you'll have a virtual charter or some kind of an academy where you're going to end up losing ADA. So the bottom line for districts is they are going to offer some kind of a virtual only model, which is permissive, does not require any medical documentation, and they are trying to protect all the ADA that they can. And I think there are going to be, so really SB 98 envisions two different distance learning models. So there is this model, which is the virtual model only for children who may be attending the entire year on a virtual basis. And then there is the other model where if things get, if things can occur with in-person instruction, the hybrid model where you've got kids coming into school in smaller cohorts, taking staggered turns coming into school, and then having some amount of virtual learning. So the distance learning manifests itself in two different places. There is the one-off, which is the virtual learning model only, and then there is the hybrid model where there is some in-seat instruction along with a virtual program, and that's the distance learning.
And Sarah and I had a conversation yesterday about the plain meaning of the language in 43503. Can we, I mean, it really did cause a bit of a stir when SB 98 came out, and how was that resolved? Or was it?
Well, it's been partially resolved, I think, because a lot of people read this. Some people jumped to the conclusion that you couldn't do distance learning except in these limited circumstances. Other people were looking at it and saying, it is kind of ambiguous. You know, in one place it says shall offer, it says shall but may. What does it all mean? And there was an intent letter that came out from two legislators about what this was supposed to mean, which that letter says that it is supposed to give districts a lot of flexibility, that it's not limited to these two circumstances, and and the letter itself says that districts are not intended to have to ask for permission from their county health in order to implement that. And so I think it's added another layer of perhaps clarity, perhaps ambiguity. I guess it all depends on your your lens. But I think for a lot of school districts, it was incredibly helpful to look at that and say, okay, then it looks like we do have a lot more flexibility. And I think that one of the big open questions is, what does that shall offer in person mean? Does it mean sometime during this whole school year? Does it mean some of your grades?
Does it mean by May? When is it? Right, exactly.
Exactly.
And so there are districts doing different things. You know, you've got some districts that are bringing in certain populations that need additional services, that require more scaffolding of support services to come in small cohorts. The most of the district is in virtual model, as they would like to begin with that, but bring in perhaps certain sections of English language learners and provide them in a face-to-face service, and bring in sort of kids in a phased approach kind of a way. So that that could suffice, the language as written by SB 98, but I think the letter that Sarah talks about is incredibly. There was CTA's interpretation, which is conforming with the intent letter, and what we had was the plain language of SB 98. But now we can say look, school board members, this is a false disagreement, because the intent of the language of SB 98 was to provide districts with this
Some
broad
flexibility.
discretion.
And Josh, going back and just before we get to the next section, just very briefly, the legal weight of letters that go into a legislative journal, or even a governor signing statement. I mean, Namita just pointed out, as did Sarah. I mean, these intent statements are now being relied upon again by by many districts to offer at the start of the year an all distance learning program. What is the legal weight of these letters to explain what the legislature did?
Well, they're considered by courts in kind of construing ambiguous statutory language, particularly with respect to the medically fragile or at risk category, which I think we're all on the same page is very broad. We had 2 matching letters from the committee chairs in the Assembly and the Senate. They obviously coordinated on those. They were issued before, I think, the Senate passed the bill, and certainly before the governor signed. And so I think we've got really good authorization from, or good information in those letters that I think leads, so supports the view that there's broad authority to offer 100% distance ed and broad authority for parents to accept that. And I would tend to agree the documentation, that we don't need to require documentation. I would add 2 points though. With regard to the shall offer in-person instruction requirement, that one I think is a little bit harder to get around. And what I'd really like to see is something from the governor, because remember last year we had the obligation to offer in-person instruction. And come March, we got an executive order that said, okay, no, you're good doing something else. And if we got an executive order or state guidance that clarified that obligation, I think that might be helpful.
That would be helpful.
Also, the state controller's office relatively soon should be issuing an audit guide, because really the key is, do we lose funding? If we provide a program in a certain way, are we going to lose funding? And the audit guide will give us a roadmap as to what auditors will be looking at. And if the audit guide says, hey, the auditors won't be looking at anything in September or October or whatever the case may be, that will give us much more flexibility to interpret this shall offer language without being concerned that we're going to lose funding. Although I would also note, if you're in a position of being concerned about losing funding, and you're in the same position that, for example, LA Unified is in, I think the odds of the state sort of zeroing their funding out and taking them over are probably pretty minimal.
Right.
But there's some more guidance that we could hope that we'll hopefully see to clarify that.
I think many are counting on that audit guide. It's already been completed for this year. They're going to be counting on it to help us move through the year, getting a little later. Can we go to the next slide? We're going to move along here. And Namita Brown from Fagan, Fullfrost, and Friedman. This changed the world. SB 98, what we did last year to begin offering distance learning and the manner in which it was done, all the negotiations, all the effort that took place between managers and teachers and classified that helped out. Well, that was the trial run. The legislature has now stepped in, and these are, Namita is going to talk a little bit about what's going to be expected of districts this year.
Yeah, and for many of us who are also bargaining simultaneously at the table with CTA and CFT chapters, there has been a remarkable shift over the short span of a week. So last week we were still talking about,
we're in dog years.
We were still talking about in-seat instruction, and we were really focused on the hybrid model. And suddenly, as many large districts are coming out and saying, due to the recent spike in cases and the governor talking about perhaps shutting down more counties, the focus has now shifted to this notion of distance learning. We were always talking about distance learning, even with the in-seat approach, but what SB 98 has done is sort of codified some of the lessons that we learned from the March through May experiment, as I call it, where we were just put in a situation and said, okay, teach. So teachers found themselves in front of a camera who had never taught remotely, now teaching students remotely, and students were learning remotely. So what SB 98 now talks about is that there has to be a daily interaction with certificated staff. It's not about daily interaction with the same teacher, certificated staff, and peer. And what that is most districts are looking at a 20-minute check-in in the morning if you're doing all distance learning. But I think the most critical piece is daily tracking and weekly activity participation. And this is to sort of track how much learning is happening in the classroom. SB 98 talks a lot about mitigation of learning loss. And I think these are data points that the legislature intended for school districts to collect to see how we are doing in imparting the instruction remotely. Now, this is not just all synchronous learning. This also incorporates asynchronous. And what I mean by asynchronous, so just for clarity, I'm sure everybody already knows this, but synchronous learning is where students and teachers are learning at the same time. So whether it's happening remotely or whether it's happening digitally or face-to-face, does not matter. Asynchronous is where the students are learning at different times. It's not happening at the same time. And that may be you have your 20-minute Zoom check-in in the morning, and then the teacher says, okay, here's the project, work on it and turn it in before the end of the class period. So kids log off the Zoom and then they work on their projects individually. They are not working together. They're not working in the same time, exactly the same way, and they're not certainly working with the teacher. That generally is the asynchronous model. And this daily tracking not just includes the synchronous teaching, but also the asynchronous teaching time. And I just want to emphasize that, because one of the things that is happening at the table is we are finding that there is no metric for this, right? So we are creating this tracking device from scratch. So if you're a Google Classroom, maybe it works because you're tracking submission of projects, you're tracking when kids log on. It's all tracked internally in that document. But if you're a Zoom school, this may not work. So I think there is a lot of pressure at the district level, at the instructional services level, and at the teacher level to figure out how do we verify and monitor progress. So there is that. There is also the equity piece, making sure every kid is connected. All of this was never talked about when we went into remote learning in March, but now we are being thoughtful about it. The idea that there are going to be communities, there are going to be school sites where there is going to be less connectivity generally. How do we address that? Again, the SB 98 is very heavy on mitigation of learning loss, and they talk about allocating monies to that. So we've got to be mindful of it. And then there is figuring out what the academic content level is, making sure that it's complying with the curriculum adopted. And all of this has to be also accommodated for special ed. Now, the really interesting phenomenon that's happening with distance learning that I have noticed sitting at the table is special ed teachers want their kids to be in the classroom, because for the really moderate to severe children, it's hard to provide learning when they are in the distance learning model. So teachers want them to be in the classroom, while you've got parents who are like looking at their children and saying, well, they're medically fragile. It may not be the best thing for them to be in the classroom. So it's a real interesting dichotomy that is manifesting itself at the table, where you've got a whole group of special ed teachers who want to be more involved than just remote and distance learning. So again, I think it's a great opportunity for school districts that have longed for some incorporation of technology in our curriculum, technology in our schools.
It's here now, isn't it? Absolutely.
Here, it's it, and we've got to work collaboratively to adopt and adapt this new model.
Thank you, Namita. And that's a great point about learning loss, because you all will be putting together learning continuity attendance plans. Our next webinar will, on July 29, will go into those plans. But as part of what you have come up with is you're looking at learning loss, not only how are you going going to make up the learning loss in 2019-20, but how are you going to deal with it ongoing in 2021? And for those of you out there that were interested, and I appreciate the fact that you are, in terms of the letters that we're talking about, the letters that went into the legislative journal, when we send out, and we'll make this available, the PowerPoint for today's presentation, we'll attach the letters that have been issued. And I did take a quick look into our questions. And so we have several. We're going to do a lightning round. I think we're going to do a lightning round for 40 minutes. But we have a couple more subjects. If we can go to the next slide, because it is a continuation of a couple of issues in SB 98 that has drawn a lot of attention. And Sarah Kotz with Lozano Smith is going to work us through this slide. Sarah?
Thank you. I do remember a time called June, which was about 400 COVID years ago. And at that time, I remember the big question was, will the certificated summer layoff window be open? And I think it was a surprise to few that window ended up being closed. So the legislature said, you can't do this August layoff of certificated employees, but did give a little bit of flexibility in there with those with administrative or supervisory credentials. So I am working with a lot of districts who are hoping that maybe they could move some administrators around. They might have to put some back in the classroom, and then they wouldn't have to do more hiring. And so that was an Easter egg in this part of SB 98, that they do have that flexibility. I'm not sure if anybody's looking at it this late in the game, probably not, but it did create a little bit of difficulty in terms of reassigning those folks, because I know that originally people were saying, well, with administrators, then could you lay them off? And the answer is, my favorite answer, well, it depends. Kind of depends on where that person is. If you reassign them to the classroom, they have seniority in teaching. So it may not have fully opened that window, but it did give some much needed flexibility. I think the surprise part came out in what happened with classified employees. Something that I know I hadn't seen before. I don't think a lot of people were anticipating until really just before this came out, which is that the layoff of custodial, nutrition, and transportation employees, so classified, cannot be implemented in 2021. And for a lot of districts, that was a huge change because they might have already been planning to do that. But then the open question that came up was, well, we kind of already did that. We passed a resolution on May 15th. We passed a resolution on May 30th, and that's going to be effective in July. Can we still do that? And now we get back to the question that Josh was addressing about intent letters and what meaning do they have. I think this was a big question mark that was left open by the legislature. And after the bill was passed, the trailer bill, there is a legislative intent letter that says the intent was that if the effective date, the final date of a layoff is after July 1, in these three categories, you can't do it. So I do think if that is a big issue for you and your district, that's something that you should really talk to legal counsel about, because it does involve an intent letter. But that's what is out there right now. Is the intent is if you had people who were going to be laid off after July 1, according to this intent letter, that is something that you would not be able to do. There's another interesting, talking about legislative intent, the very beginning of this section, which is section 94 of SB 98, it actually says it's the intent of the legislature to retain all classified employees. But then it just goes into provisions primarily about layoffs. I have heard that CSEA is pushing on that particular sentence, saying, you don't get to get rid of anybody. But I think that you have to follow through and read the rest of the statute and say, okay, well, that may have been their deep desire, but what they actually told you can't do is contained in section B, and that's the nutrition, custodial, and transportation. So then the next piece of that is that section B says that nothing in that section is meant to stop you from releasing custodial nutrition transportation employees for good cause during 2021.
What's
So
that
what does
mean?
that mean? That's a great question. What does that mean?
I beat Marie to the punch. No, Marie was.
I think that with permanent employees, what that means is really what we're used to is if you built a case, somebody who has not been a good employee, you can still go through a for-cause termination and terminate them. The question that I started getting, however, was what about probationary releases? Can we still do a probationary release? Not crystal clear, but I'll tell you what my take is and then see if there are other points of view on this, which is for probationary releases, although we always say that you don't have to show cause. You don't give a reason. It can be for any non-discriminatory reason. The fact is there usually is a reason. There usually is cause. And I would argue that if you would want to make sure that you have some kind of a reason there that you could go back to show why you did it. But I do not believe that the legislature intended to cause school districts to have to keep sub-performing, non-performing probationary employees until they become permanent, and then you can build a case against them. So I would say, make sure you have some documentation, know what your cause is, but I would not tell somebody that they cannot release a probationary employee under these circumstances.
And then on the other side, don't we have some that are being advised that good cause might mean a modicum of due process?
I have heard that argument, and I think
heard that argument. I heard
that argument. I know Josh had an opinion on this. I don't know if you want to jump in. I'm happy to give mine as well.
Sure, I can chime in. In our view, probationary employees have certainly less of a property right than permanent employees, and we know what a for-cause dismissal process looks like for permanent employees. I think for probationary, both as to the cause and as to the type of I don't want to necessarily use the word hearing, but as to the type of due process proceeding that's provided, I think it's going to be a lesser standard. I think you need some reason, if it fits within the framework of good cause, great, but I think you need some reason to let a probationary employee go. And I would suggest that you identify some process. For example, a lot of superintendent contracts indicate that if you're going to be releasing a superintendent, that they have an opportunity to talk to the board, that there be a meeting. It could, for example, be something like that. I don't think it needs to be as complex as bringing in a hearing officer, having witnesses testify under oath. I think it could be much less informal. And this really, trying to figure out what's cause and what's required in terms of due process. This should be really a question that you're talking to your legal counsel about, and come up with a process that makes sense within your district, given the facts you're working with and the situation you've got.
Thank you, Josh. So just as a time check here for the panelists, we're about 11:48. I've asked for permission to go 5 minutes over since we started 5 minutes late and because I talk too much. So we're going to go to the next slide, and then the slide after that, we'll see if we can get done in the next 12 minutes. I've got a lightning round here I've been messaged on my phone. I think these are questions that we can get to and really benefit those that are watching. We won't spend a lot of time necessarily answering the questions. It might just be a vote with the thumbs. But in the meantime, there's a lot of questions that came in before we started this morning on this issue. And I've asked Marie Nakamura with Dennis Walliver-Kelly to handle this subject here.
Thanks, Keith. So before I get into talking about liability, whether a district is legally responsible or financially on the hook in a legal way for a student, a visitor, or an employee contracting COVID at a school site or in a district or LEA building, I want to point out that I recognize this conversation seems rather cold, that I'm going to talk to you about whether or not we have legal responsibilities, and in light of the crisis that we're all in, it's not a very comforting conversation to have sometimes. I also want to point out that the tension here that we've been talking about kind of all morning is between two very important concepts here. You have the constitutional right for children in this country and in this state to have a free and appropriate public education. And that's, we talked about Prop 98 and how important that is in mitigation and making up for what was a failure for some of us last spring in the middle of the immediate crisis. But in conjunction with that, we also have this concept of keeping our students and their employees and their families safe. And so that's kind of how those two concepts fit together. Is there an increased risk arising from reopening schools? That's kind of the question at the table at the top of this slide. And there is a risk, an increased risk, only if we in the LEAs don't follow the directives we've talked about earlier, some of them that Josh mentioned, the orders from the governor, or what's being produced in our own counties by our own county health officials. So although it sounds scary, if we stay in that bubble and we follow the protocols that are being required by our counties or by the state, then we are as entities much more protected, and I'll go into some specifics here in a second. And also I think it needs to be said, because I know I'm speaking mostly to school board and other board members here today, that the general rule is that policy decisions made within the scope of your jurisdiction, within the scope of your authority, policy decisions that you make as a legislative group together, there's a lot of immunity protections in the law for those types of decisions.
Bingo.
That goes to school boards and other governing boards, county office boards, and as well as elected superintendents, because that's you were elected to provide legislative policy decisions to the LEAs that you represent. So I wanted to get.
But if it gets down to it, the courts will give great deference to those
The courts give great deference. Also, a couple of other points here as far as whether we're at increased risk of liability as LEAs. In California, I can't speak to places other than California because I'm only past the bar here. But in California, if you're going to be held responsible for a tort, for basically a civil wrong that you didn't, like, such as negligence, and many of us have been in car accidents or that type of thing. If you're going to be held responsible for that, there has to be a statute that gives the reason for that liability. And so there won't be a new coronavirus civil cause. It has to fit into any of the other statutory causes that we have under the government code. For example, negligence. Did you have a duty, basically, you have an action or reaction and a duty to protect, as we remember from law school. And that concept is also found in the government code. And we've talked about this a lot when we talk to school boards about government torts and that type of thing, when we come in and talk to you in closed session when someone files a tort claim or something like that. So that's just something to keep in mind, that there's not going to be a new cause of action that comes out of the coronavirus. It's going to have to, if there is litigation, it's going to have to be tied to specific, generally government code claims for damages. And not only do school board members have immunity, but the employees that work for them also have levels of immunity if they are acting on discretionary matters. And I know this all sounds like a law school lecture, but if an employee has a choice between, in this time, let's say, between doing A or B, and they choose A over B, and maybe B was better, they still would have immunity because they had that discretion. If they don't have that discretion, if you must do A, whatever A means, and if some of the conversations we've had, if A means you must provide 6-foot social distancing, and we're not saying that that's the case, but if that is what the rule is, and a school district employee elects to do something different, maybe give 2 feet social distance or no social distance, then that's where a district as a whole could open itself up to liability, in that it's not allowing, that's not a discretionary decision if the rule in your particular entity, your particular county, your particular district is 6 feet of social distancing. So that's just one example.
Let's use another example, because I've seen we have a number of questions on the face mask. And the outstanding guidance by the Department of Public Health saying there's no exception except for younger kids and students or staff that might have health conditions. Isn't it a correct reading of that guidance as it is presently written that it's going to apply to schools and their facilities when they open up for business, that face masks will be required indoors?
Yes, that's the way. Oh, go ahead, Keith. Sorry.
That's the current interpretation, right?
That is the current interpretation. Obviously, there are exceptions for students who may have a reason not to wear that mask, but that doesn't mitigate our responsibility then to have other measures in place.
So what if a board decides, man, we're going to make all we can to do our distancing, but we're not going to mandate masks for our students, or we're only going to mandate them for high school, not for middle school or elementary? In terms of the liability potential, what is when there is an outstanding mandate? I think that's what you were getting to.
That's right. And so in certain, again, let's say the board made that decision. The board itself may not be held personally responsible for that decision, because again, there's a great deal of latitude allowed to elected folks in the state, and elected boards in particular here, to make policy decisions, even if those policy decisions go against the high recommendations, or even in some of these cases, actual orders. But that doesn't mean the entity itself wouldn't be held responsible.
That's right.
Because the entity itself would have made a decision contrary to the mandate from, in this case, the state of California.
That's correct. So why don't we move, and that was the underlying point, that board member liability, you're sitting in a sea of discretion that you can exercise. But depending upon what you do, if there's a mandate, you don't follow the mandate, then it's going to come back to the district. So let's just be real quick with waivers. What you got waivers up there?
And I've had a lot of questions from school board members in particular, and superintendents, about can we have somebody waive any lawsuit, pre-waive any lawsuit against the district for catching COVID or being exposed to COVID in an educational environment? And the short answer to that is no. We can get waivers, though, for extracurricular, non-mandatory school activities. So, for example, you wouldn't be able to get a waiver waiving liability for a student coming into a classroom, because that's the whole purpose of our organizations, right, is to educate students. However, there is an allowance, and many of you who are parents have signed waivers with regards to, for example, athletics that are outside of kind of the core purpose of an educational entity. And so there is some belief that we could ask for waivers if a student is going to participate in, say, basketball or some other extracurricular activity that would bring them in close proximity to other students, and where we would not be able to follow whatever county mandates we have about social distancing.
So clearly compulsory education negates waivers by and large, but if you're looking at those voluntary activities, you would suggest that work that out with your legal counsel. And then just real
Correct,
quickly, if you could give just a few moments to the legislation that's been introduced by Assemblymember O'Donnell.
So as many of you know, Assemblymember O'Donnell introduced AB 1384, which largely, in my opinion, kind of codifies much of the law that we've already discussed around liability. And it says in the current version of the bill that we have now, it directs school districts, right, to establish policies and procedures for operating programs and basically containing COVID-19. And if and when someone does that well, then there will be no monetary liability for a whole list of tortious activities. And
So
it doesn't
you're
protect.
consistent with guidances, you're consistent with executive
Right.
orders, whatever it might be, just be consistent with what's out there, the legal framework by monetary liability.
And a lot of us already have started plans. I wanted to make this quick point before we move on, is that there is that section of the labor code, and I don't remember, it's 6041.7 or 6401.7, that requires employers, but specifically school districts for our purposes and county offices, to have an injury illness protection plan. The CSBA has a model policy about that. And so we have, as governmental entities, already gone down this road. We may not have looked at them in a number of years, and some of them have been updated, working with insurance companies and JPAs over the last few months to include illness and injury prevention programs specific to COVID-19. And this is where it's really important that the board, the superintendent, and human resources are also looping in risk management folks, because oftentimes what happens is the risk management person will update this. It may go to the board as a consent item. Nobody else in the district really has taken the time to read it. We're too busy doing all of the rest of this. And so I think it's very important for school boards and superintendents to kind of loop back and say, okay, what have we promised the public that we're going to do, either pre or post COVID, in order to diminish the likelihood of illness in our LEA? And that dovetails right into this whole liability conversation.
Well, I hope that has answered many of the questions that have come in. We'll get to them as well. Let's go to the next slide. And so we refer to this fondly as the all skate slide. This is what are the issues at the bargaining table. I don't think we have a lot of time to go into the specifics. I do know we will actually want to start at the very bottom with what should go in and really what should be left out of MOUs that you're negotiating. And we'll also rely on the panel to talk a little bit about, what's going on, what their experience at the table is with their labor partners, as well as the critical question, well, what if we're still bargaining when school begins? So Sarah, you want to take on the notion of the MOUs?
Yes, absolutely. I think at this point, we've probably all seen a few examples of what's coming out from the unions, both from classified and certificated side. And I have a few do's and don'ts, but as an overarching issue, I would say, think about the fact that this MOU is going to be in place for a period of time. And in all likelihood, what you may write into there is that period of time is this school year. So you need to look at every provision that you're putting in there as, is this going to work over the whole next year, even though I don't know what's going to happen? Meaning, I've seen provisions that say there will be no in-person staff meetings. Okay, you may read that right now and go, well, duh, we're going back distance learning. We're not going to do this. Is that still going to be something that applies in April? What if there's a vaccine and things are a lot more normal in the spring or something approaching normal? I think you need to be looking at each provision in terms of how is this going to play out over time? Does it give you the flexibility to move between what might be shelter in place and what might be a lot more freedom in the spring? But a couple of things, and I'll start perhaps on the don't side. With what I've seen in some of the MOUs, a lot of them start with a laundry list of the district agrees that it will comply with CDC, CDE, local health, and list, everybody, my Uncle Bob, whoever it is. And your Uncle Bob may be pretty smart, and so perhaps is the CDC. But I think that you need to think about what is actually mandatory and only agreeing to comply with what's mandatory. Because the problem is, if you agree to comply with 7 things, and as those evolve, they conflict with each other, how are you really going to comply with that MOU? So that's one thing. I would be very careful about what you give away in terms of leaves. I've seen proposals that no leaves should run. I think hand that over to your CBO and have them do a little math. That may answer the question for you. Video learning, I know that that has been an issue in some places, but again, I would say be careful about what you're looking at there. And then the last one that I'll throw out is a lot of the proposals I've seen has the unions trying to bargain the rights of other people. So you won't do this with students. All employees must. Each unit is bargaining for their unit. And so I think that the school district gets to decide what's best for students and how you're going to protect students. And I don't necessarily think that that belongs in your MOU. And I don't know if other people, Keith, did you want anybody else to address any of their do's and don'ts? I have a couple of do's, but other people may have better ones.
Well, let's stay on, I think, because I'm looking at the questions that are coming in, and you touched on that with leaves. How do we get employees, or do we get employees to come back to work that are not wanting, if we have an in-person classroom that they're to teach in, and they're concerned about their own health, how do we get them to come back? Do we use leave when they run out of leave? What those issues are throughout the questions in the chat room. Anybody? This is all skate.
I think.
No,
go ahead. Sorry, Sarah.
No, you please.
I think CTA has made it very clear that employee safety is extremely important to them, and you know, it's a completely understandable presumption. I think where we are having issues is this idea that if you've got a group of people who don't feel comfortable coming back to work, and we've gotten past the language of don't feel comfortable, it's about either people who have medical conditions or who are caretakers of people who are identified as the vulnerable population as part of the COVID-19 series. If you are a caretaker of that and you don't want to come back to work, what do you do with those employees? And what the proposals are at the table is that you go through some kind of an accommodations process with them, and you give them a remote learning only model of instruction assignment, and that they are in that remote learning assignment for the entire year. And if you can't provide an accommodation like that, they remain in paid status for the entire year, right? They get a year's worth of paid administrative leave. That is what the proposals that I've seen say. And let's just also be clear, this is just a starting point, because I've reached agreements which do not have the language that they will stay in, you know, a year's worth of paid leave. The bottom line for districts to think about is, are there going to be assignments that you can utilize where you have the opportunity to provide a safe space for your employees who cannot come back to work because of medical conditions? You just can't get to a scheme that sort of gives super accommodation rights to people who've got COVID-related issues while it does not provide the same kind of rights to people who may have other medical conditions such as cancer or whatever. So you've got to be sure that there is some kind of equity in the lens that you provide, but this is a real thing, and there is no one-size-fits-all approach to this. You've got to look at it from an individual basis. It depends upon the credential. It's probably easier to accommodate a single subject, I don't know, math teacher than it is to accommodate somebody who's got a single subject French credential, because they may be teaching different cohorts of children. So I think when you are at the all distance model, this is not that big of an issue. We can work around it. I think it becomes a real issue that you have to work collaboratively with the union, with the teachers at the local level, taking into account need, district needs, programmatic needs, and credentials, and the accommodations requested by the individual.
And just to follow up on a point that Sarah was making, I think the key word is flexibility. We don't know what the health situation is going to be like, and it varies from one county to the next. We don't know what the financial situation is going to be like. I think there's some hope that we may get federal funding, additional federal funding, but is that going to happen? Is the president going to sign a bill that provides additional federal funding to districts that are doing hybrid models? Who knows? The thought that we're going to have a lot of federal money come in by October and we'll be able to just keep this train going, I think that's in doubt. We may find ourselves midway through the year with much more of a funding crunch than I think than So if you were to include something in an agreement, my thought would be to preserve flexibility, retain the right to reopen, expect that something is going to happen that will necessitate going back and revisiting the agreement and negotiating based on the circumstances, both health, both health and fiscal that are prevailing at the time.
Well, let me start asking some questions rapid fire. We've got about 25 minutes. What happens when the union and the district do not agree on a teaching and learning model?
I can address that. The district instructional models are not sort of the curriculum itself is not negotiable. That's a consultation item. But if you're at the point where you're supposed to be starting school and you don't have an agreement, let's go back to March. We sent everyone home. We often didn't have an agreement in place that accounted for that. There is some authority that's built into PERBs recognize this in some context. We've got to do what we've got to do to keep the schools running and operating. And if we don't have the time to negotiate items that we normally would want to have fully resolved before school starts, then we've got the ability to get the year up and running, to continue negotiating and to do what we can. There are practical concerns. I mean, there are obviously practical issues. If we don't have a plan to bring teachers back in a way that the union is on board with, could they go out on strike? Potentially. But just as a legal proposition, I think we are okay bargaining as quickly as we can, as efficiently as we can, but also being able to start school, get our programs up and running, even if we don't have all the signatures on that bargaining agreement.
And I'd like to point out that the status quo really is to have the teacher in the classroom, right? That is what we did in the spring throughout the state, and some very, very well, and some not quite as well, was an anomaly. That is not the status quo. The status quo is for on August 15th or whatever the date might be, for teachers to come back, set up their classrooms, and be ready to teach 2 days later. And that might sound a little harsh, but that's the reality. And so whether the students are there or not is a different issue. And so my advice to clients is, even if you haven't gotten to that point where you have an agreement, do the other things we talked about today. Make sure that you've done the deep cleaning and you're following all the other guidance. So there is the union can't argue we're not going back to work to teach remotely because it's not safe, because we've already done the things that we need to do.
Marie, what about a question that came in? Even in a distance learning environment, can districts require teachers to teach distance learning from their classroom?
I believe they can, because that is the status quo. And PERB obviously has not addressed this issue, because this is, at least in the 20 years I've been doing this, is the first time I've seen anything like this.
Okay. So under negotiations, a question came in, and we'll want to take these quickly, everybody. What about evaluation and tenure decisions on, for example, with the second year probes and the evaluations? How is that going to be accomplished, and is that coming up at the table?
All over the place, and I think the starting position for unions is that there will be, the evaluation article will be suspended, and I have reached agreements where we've said that we will have evaluation for probationary and temporary employees, and if somebody wants to be part of the evaluation cycle, they can volunteer to do that. But you've got to have some good cause to get rid of people who are not, who you don't think would be successful teachers. And in order to have an objective criteria, you have to evaluate your probationary teachers.
Thank you, Namita. Now, many questions about social distancing, and we are going to take care of that in 2 weeks. But and we know we expect the governor to come out with something on busing by the end of the week. Well, how about the 6-foot requirement on for busing? Noting that the American Academy of Pediatrics is recommending 3 to 6. Anybody want to throw in on that?
I think that starting with some, see what your local county health guidance is, because I think that you're going to see some variations there. A problem that I'm seeing at the table talking about 6 feet, and I think that you're going to experience the same thing out into your parent community, is everybody has heard 6 feet for so long now, you know, for 7 billion COVID years, you know, almost since the beginning, that it's internalized, and people, I think, automatically have a feeling of unsafety when you talk about that. But there is data coming out that can be smaller. There's the American Pediatrics Association. Some of the county health professionals are saying that 4 feet may be enough, particularly if you have face masks. And I think that you just need to keep following what's actually being released either from CDPH or locally, and color within the lines on that liability issue.
And let's go quickly. I'm sorry.
No, I just wanted to make a point here that and it's a huge issue in transportation, because CSEA is putting forth a lot of proposals around how kids will be seated in a bus. And remember, we can't lay off transportation employees, so you have bus drivers for the next year. So county health is your best resource, because the quickest way you can get buy-in from a union is to say to them, here is the guidance from our county, here's the guidance from our county Department of Education. That is where you have to pair up with your county office of ed and get them, put pressure on them to get you the guidance so that you can get objectives at the local level.
So I've got 3 questions that ask the same question. And that is, and Josh, I'd like to answer real quickly with yes or no. County Department of Health orders, are they optional or are they mandatory?
If they're worded in a way that says they're mandatory, you shall do this, then yes, they are mandatory. A lot of them are presented as, you know, do this if feasible, or, you know, strong recommendation. It's important to look at the actual language. But yeah, if they're put together in a way that you know, attempts to impose a mandate, yes, we think those are lawful and enforceable mandates.
So there are questions that are coming in about kind of the hybrid model when you have both online and in person. How is that accounted for? Well, one, you're counting for seat supervision time, and the other, you're counting for the value of the work time. It's going to be, does anybody have some more clarity on that? It's really going to be an accounting feature in order to be able to get the number of minutes in a day. Is that correct?
It does. It talks about that the asynchronous time will be utilized for purposes of counting towards instructional minute. And I think what districts are doing is utilizing their teaching and learning committees to set out the parameters around asynchronous learning, because what you don't want is homework, which also happens off the regular synchronous clock, to be conflated with asynchronous learning. So please utilize a metric that is implemented district-wide, and it incorporates the expertise of folks who do teaching and learning.
Okay, now this is throughout the questions. What happens if you have in-person instruction, whether it's total or part of a hybrid model, and the teachers refuse to return to work? What happens?
I think it depends on what is their reason for not returning to work, right? So let's say, so teachers cannot withhold, and this is, teachers can't strike just because they want to strike, and that's basically what that would be. In order to have a legal strike in the state of California, if you're a teacher, you need one of 2 things. Either you've made it through the impasse process, not reached agreement, gone through fact finding. That's not going to happen between now and September 1st. For any district in the state. The other way that a group of teachers may withhold their labor and participate in a strike concerted activity is if the district has created a circumstance where there are so many unfair practice charges occurring that coming to work really is not feasible. And so that would need to be their argument. I do think that we could be facing a nationwide teacher strike, just based on, and we haven't talked too much in this is probably not the place, but based on what's happening on the national stage and how that is seeping into, even for those folks that don't do what the groups of us do for a living, everybody is talking about the safety of teachers. And so I do think that there is that possibility, and it's going to be something very new for all of us, because we won't have access to pre-planning and substitutes and all of that.
Thank you, Marie. So we have 15 minutes. I'm going to try to do 15 questions. And if you want to rebel, just do so openly. So this notion of daily live instruction, and there was modification of the law says, well, if that doesn't work, it has to be at least frequent. Does every subject have to be taught daily live? Or is there flexibility, right?
There is flexibility.
And keep in
I'm
mind,
sorry, Namita.
I'm sorry, what?
I think there is flexibility. I think the idea is having interaction with students.
and keep in mind the instructional minute requirements are less. You need to hit your minimum instructional minute requirements, same as always, 180, 240 minutes a day, but you don't need to provide the annual instructional minute requirements have been waived. So you've got, there's less of a bar to get to in terms of adding up your minutes and making sure everything works. So I think that builds in a little flexibility in terms of how you set your schedule.
And what are the specifics? The question is, are there still truancy requirements? Aren't there some specifics now for how many times a student has to be reported a week, and what are the consequences? Let's say if they don't make 3 days a week, what are the consequences for not doing so? Is there any consequences to the students, or is that a consequence for the district?
The
Attendance recording is required at this point, and in the SB 98 shows, you know, these are the types of things, whether they might show up on video, they might interact individually with a teacher, they might turn in an assignment, and all of those things can count them towards attendance. But if there is kind of no touch with that student, that they are absent for that day. And although I think that many districts will take a softer approach than diving right into SARB, you know, doing more outreach to that family to figure out what they're going to do, yes, there is an attendance requirement.
Right, and if a district is not keeping those requirements, if it's not showing it's re-engaging with those pupils that are absent 3 days a week or 60% of the instructional time, then there can be a ding on the apportionment, and that's something that we can cover in the next seminar as well. This one has come up several times for me while I've been on the road on Zoom, is what happens when students remain in distance learning, if they choose distance learning, but then to start, and then they choose to move into in-person, or vice versa. They're in person and then want to go to distance learning. Can the district keep them in the program that they have chosen to begin with?
So I don't think this is a legal issue per se. I think this is how districts are creating their program. Because I think most of the times, if you are in a virtual model, districts are utilizing pre-canned curriculum, and the teacher is acting like a case manager per se, like they may be using Acillus or some kind of credit recovery model for purposes of providing that distance learning only option. So for purposes of not having a loss of learning, districts are putting in specific checkpoints that you cannot come back into the regular program until either at semester break or trimester break, or it's a whole year opt-in. So districts are making that decision, but that is a program design issue.
Thank you, Namita. A question about going back to the order that came out yesterday from CDPH. And this is how it's written about the education sector, tier out of 4. Individuals, and in terms of priority for testing, individuals who work in the education sector who have frequent interactions with students or the public. So that's how, if you then have to go through your classifications and figure out who that might be. We still have these questions about complying with the county order, and I think that we've answered those. One question, this is a softball, are para educators protected from layoffs?
No.
Sarah?
I'm sorry, I was muted there for a moment.
I'm
I had
sorry.
some background.
Oh,
That
okay,
is
anybody,
not,
are para educators part of the classes of classifications protected?
No, no.
no.
This notion of, it comes up, and this can be an easy answer. There's still this talk out in the wilderness about furloughing employees. Is that something that is being discussed at all by management or at the bargaining table?
To some extent, I think a furlough is distinct from a layoff, so I think potentially that's available, but there's less talk about it now than there was, say, a month or two, and we may, come October, there may be more
Right.
talk about it.
So this is a follow-up to that. If we go opening with distance learn, well, this is more of a, this is kind of a polemical question. Why do we have to keep the transportation employees if we open up with distance learning? Well,
The statute said
we
so.
already talked about why.
Yes.
Let's see. I'm sorry for, well, again, it goes back to a question, can teachers say no to their assignment in person versus distance learning? And I think Namita talked about how that's coming up and how that then is an accommodation that districts are making. Is that correct?
Yes, and I think Marie talked about the pressure points from a national movement. I think it's not just strikes. I think we are also, there are districts that are hearing sick out, threats of sick out if we don't reach some kind of a agreement on remote learning assignments for teachers. So it's an issue, but you also have CTA chapters that are, and CFT chapters that are agreeing to having language that says people can come and work from their classroom, because we may be in distance learning mode, but there are teachers who prefer to come and work at work.
How about this one, going into the workers' comp world so briefly? What if a teacher falls over their dog at home during their instructional time? What about, how would we work that out?
They fall over their dog?
Yeah, what if they get hurt while they're at home, while they're doing their distance learning?
I do think that if that is actually during their work time, I would advise the district to, first of all, talk to your workers' comp carrier, but give them the paperwork to file that, because that's ultimately going to be a workers' comp determination as to whether or not they were on work time doing work duties at the time. But I do think that there is a potential there for a workers' comp claim.
Thank you, Sarah. Teachers have resisted widespread use of cameras in the classroom. They have said the ed code says the teacher, and actually it's the principal, have control over this. What are our comments about having teachers, requiring them to use either a recorded video or live stream?
We don't see that statute as limiting districts or preventing them from using Zoom. There could be an issue if the district is requiring that the Zoom meeting be recorded, but even there's a little bit of a gray area in the statute. What we can't do is like in a regular classroom where recording traditionally is prohibited. We only have limited ability to prevent students from recording in a normal classroom with their phones. But I think we can certainly have Zoom in use and require Zoom or other platforms be used in a distance ed setting without being in violation of the prohibition against classroom recording.
And I think that it's Ed Code 51512, right? It was established in 1976. It predated everything, including our ability to do this particular webinar. And so I was very grateful, as much as I've complained about SB 98 over the last couple of weeks, I am very grateful for the fact that they did address some of that in there. And so it we are contemplating using video and other technological means that may end up recording. And so I don't think that 51512 applies.
Quickly,
I think, if I can just say this, I think the issue that teachers are most concerned about is the projection of their image. So that's what they're most concerned about. And I think if the conversation is sort of shifted to not having the teacher's image be projected, but if it's the screen or it's the document that is being shared be projected to the group at whole, I think that conversation, that fear sort of erodes a little bit.
And I've had clients who talk to students and have them sign something that say, we understand that, you know, if my teacher is teaching that we're not going to record this, and it may be enforceable or not, but at least it's in the student's mind that they shouldn't be doing that.
I just have time for a couple more questions. Would interaction with an aide or classified staff count towards minutes of instruction?
No, I think you still need either in person with a teacher, or you need time value as determined by the teacher if you're doing distance ed. I don't think, you know, time with a classified employee or a non-teaching employee is going to, you know, count towards minutes in the same way that time with a teacher would.
And a question specifically for Namita: do doctor's notes come into the accommodation discussion in terms of teachers that are not wanting to come back to work?
In every TA that I've had, we've had documented medical notes, yes.
Oh, so Sarah, you're still interested in your do's and your do's for the MOUs. Why don't we, that came in at 12:21. Why don't we finish, and if there's any closing comments by others, I'll entertain those, and then I'll do the closing slides. But you had some do's and I cut you off. Can you quickly?
I'll hit three really quickly.
Really quick.
One is that employees will report unsafe working conditions so that they understand what their responsibility is under this rubric. Work expectations to get into an MOU where there is a lack of clarity on what is it that people are going to be expected to do and what standards are they being held to. And lastly, it could be a do or a don't depending on how you frame it, but as much flexibility as you can possibly get with transfer and reassignment, because we don't know what the next 10 months are going to look like. And don't tie your hands. See if you can actually go the other direction and get yourself the maximum flexibility on utilizing your employees.
Thank you, Sarah. Any parting shots? Any closing comments? I want to thank you.
I think it's just it's a work in progress. Have a live contract committee, keep meeting regularly, and keep problem solving.
You know,
go ahead, Josh.
I was just gonna say, buckle your seatbelts, and you know, again, be prepared to be flexible. I don't think anybody could have written the last 4 months, or if they did, it would have been rejected as implausible. We really don't know what's coming down the pike, and we're just gonna have to. I think for the most part, districts and unions have been working collaboratively, maybe not so much in the last week, but have been trying to work together collaboratively. Maybe I'll put it that way, to keep things going and to provide instruction for kids. So be prepared to be flexible.
Marie?
No, I would just agree with what my colleagues have just said. For those of you who attended the school services update yesterday, they had a slide on and it showed a picture of a roller coaster to depict what we've experienced this last year. And I thought that their roller coaster looked like too smooth of a ride to actually be 2020. There were no upside down loops. Nobody got thrown out. So just,
yeah,
we're here for you folks if you need anything.
We're still on it. It hasn't stopped. But okay, let's do some closing comments here. For everyone that's watching today, please note we'll be sending over a draft this afternoon for an email to all registrants. It will include PowerPoint recording letters and a survey on the experience of members. And it's going to be sent to you all tomorrow. And maybe I wasn't supposed to read that one. And then yes, we are recording this, and it'll be archived in the webinar section that you'll be able to access under csba.org/webinars. And I want to thank you all for joining us today, and especially those who contributed questions. I envision a webinar where we just answer questions. So I'm talking about buckling up your seatbelts panel. I think that's a very realistic thing that CSBA will be doing in the future. CSBA is dedicated to providing up-to-date resources to school members during the COVID-19 crisis. To view our recent report on reopening schools, the uncertain road ahead, please go to our webpage at csba.org/COVID-19. If you are interested in attending future CSBA webinars, please go to our website at www.csba.org webinars to register for any upcoming webinars. The second part of this series will be on July 29th. We're going to be dealing directly with the special education issues, social distancing, and we're going to talk about the new learning continuity attendance plan. We will also be having a webinar upcoming this Friday related to deferrals and the cash reserve program. So many thanks. Biggest thanks of all to our presenters, Namita Brown, and to Sarah Kotz, Josh Morrison, and Marie Nakamura. You guys did a great job. With that, thank you all for joining us today.
Thank you, Keith.
Okay, thank you.
Thank you. Bye.